Welcome, everyone. Thank you again, Heatham, for inviting me to speak with the RRAI. For those of you that don't know me, my name is Samantha Carter, and I've been working in human resources for over 20 years. Initially as an in-house human resources professional, and in recent years in a consulting capacity, and also as the founder of a software company that provides investigative software to small to mid-sized businesses. A large portion of my career has been spent working on, thinking about, talking about, and improving health and safety in the organizations with which I worked, all with one goal in mind, and that is to ensure that you return home in the same condition in which you came to work. So today's session is really for you, and it is about your rights as a worker in this province. Canada has fairly strong laws designed to protect workers in the workplace. But those laws, although they are helpful for organization employees, they only really help if you know what they are and what the expectations are around them. So in the next 15 minutes, we are going to talk about four things: your health and safety rights, what happens or if you get hurt at work, and your rights when returning to work after an injury, and your right to be accommodated. At the end, I'll tell you where you can go for help if you ever need it. And I know that's a lot to cover, so I encourage you to focus on the main ideas, and you'll be able to look things up later. So let's get started. So the Occupational Health and Safety Act of Ontario is what governs health and safety in the province and in most provincial workplaces. In Ontario, that law protects you while you're at work, and workers and employers often call it OSHA. It is also, there will be a green book that houses the act posted somewhere in your workplace. Most organizations have a health and safety board where they keep track of minutes of meetings, where they keep track of health and safety information or materials that you might need to know about. And they typically also post as a requirement what's referred to as the green book on that bulletin board. It'll usually be attached by a stringer or something like that. So under this law, you have three core rights, and these rights belong to you no matter what, no matter where you came from, what language you speak, or how long you've been in Canada. You cannot waive away or opt out of your health and safety rights. So these are them: the right to know. So you have the right to know about the hazards that you may face in the job. You are entitled to training before you do work that could potentially expose you to those hazards. For example, if you work with chemicals or hazardous materials, this will include something called WHMIS training. It is important that if you don't understand the training, maybe because of a gap in language, maybe because it was rushed, you can ask for it again. That is your right. It's not a favor for them to further explain the details of the training. And we all learn at different paces and different rates. So if there is something you do not understand as part of your health and safety training, it is acceptable and encouraged for you to speak up and ask questions. You also have the right to participate, and that means you have the right to speak up about safety. You do not have to wait for a formal process to raise a question or a comment or ask for further clarification. In larger workplaces, there is something called a joint health and safety committee. Usually, if you're in a small workplace with less than 20 people, you may have a health and safety rep, so it's important to know who that is. Usually as part of your orientation training, when you first begin working with an organization, they will inform you of the details of the Occupational Health and Safety Act and how it pertains to the workplace. But they'll also share with you information about the Joint Health and Safety Committee or who the designated health and safety representative is. And you are allowed to be part of that solution. Oftentimes, the workers within the workplace will vote on who they want their joint health and safety reps to be. So you can always participate in that. You also have the right to refuse unsafe work. This right comes with a very important responsibility. If you genuinely believe that a task is dangerous to you or to a coworker, you can refuse to do it. There is usually a very defined process on how to go about that in your workplace. So it's really important that you raise it properly. Initially, if you can bring it to your employer and say, hey, this doesn't feel safe. I don't feel like I have had the proper training with which to do this. Can I have more training? Can I be shown how to do this? And typically the issue can be resolved then and there. If it goes further and you really don't feel that it is safe for you to continue that work, then you must raise that to the organization and they can give you alternate work while they investigate it. They are obligated to investigate your concerns when it comes to work refusal. So while they are conducting the investigation, the organization can give you some other work to do during that day. They should not be sending you home or letting you go unpaid for that time. During that time, you should be able to just be assigned to another task while they investigate what is unsafe about the work that they have assigned to you. So these are very important responsibilities that pertain to every employee in the workplace. So we are responsible for following safe work practices and procedures. If we've been trained on a process or a safe how to use protective equipment or anything like that for the job we are required to do, we must follow those safe work practices. We must wear that protective equipment as it is prescribed for us to use it. It's really important that we wear it the way it is designed to be used so that it can work effectively. Our other responsibility is to report hazards and injuries as promptly as possible. So if we notice a hazard in the workplace, it's really important that we raise that to our supervisor or manager. And then if we become injured in the workplace, we should inform our employer right away of that injury. And one of the key things is to avoid putting either yourself or anyone else at risk through any type of action that is not approved by the proper work procedure or engaging in anything that could be perceived as inappropriate in the workplace. This is another important thing to know is that your employer cannot legally punish you, terminate your employment, or cut your hours for raising a health and safety concern. That would be considered reprisal in the workplace, and that is prohibited by law. So they are not allowed to do that. That said, if your organization finds that you have been engaging in a way where you are endangering other people or not following the safe work practices, it's really important to know that they could potentially discipline you for not following safe work practices. However, if that occurs in response to you raising a health and safety concerns, that would cause some concern over the way in which that would be handled. So it's just something that is important to know. What happens if you are injured in the workplace? We do have something in Ontario called the WSIB, the Workplace Safety Insurance Board, and it is a organization that helps protect you from lost time when you are at work, if you are injured at work. It is a no-fault system, which means that if you did something in the workplace that did cause you to be injured, it doesn't really affect whether or not you're entitled to benefits. So you don't need to prove your employer did something wrong. In exchange, you generally cannot sue them for injury while in the workplace, and the system supports you without any type of lawsuit or court battle. So 3 things you need to do if you are injured at work is, of course, if it does require medical attention, you need to seek medical attention right away. You need to tell your employer as soon as possible what's occurred, how it has occurred, and participate in the documentation process for recording a workplace injury. There is a form that the company would fill out. It's called a Form 7, and that usually gets submitted to WSIB so that they can report your injury to WSIB, which would typically initiate the process if any benefits were going to be paid. On top of that, there is an option for the employee to report their own workplace injury, and that would be with a Form 6. The doctor who you go to see to seek medical attention will submit what's called a Form 8 to the WSIB. So that is the corroboration from the doctor that you have injured yourself in the workplace and will detail what the injury is to WSIB so they can properly manage the claim. So essentially, we've talked about what you need to do if you get injured. We've talked if your employer does not does not file a Form 7 with WSIB and you haven't informed them you've been injured, you can always file a Form 6. However, I would always go and speak to your employer to confirm that they have filed a Form 7, especially if you have any lost time. There are very strict timelines on for how long There are timelines that employers need to adhere to in order to file a report with WSIB. Usually it's within 3 days that a report needs to be filed with WSIB, and that documentation is really important. So I would recommend that you keep your own notes as well regarding your injury, what happened, where it happened, how it happened, because you will probably need to provide that to your employer as well, especially if there was one documented on the day of. And then that documentation would be part of the report that goes to WSIB. And it can help protect you as well if there's any type of disagreement. The type of benefits that you may receive as a result of WSIB claim is that you can get wage replacement. Ideally, the goal in the aftermath of a workplace injury is to have you return to work as quickly and as safely as possible. Studies show that the longer somebody is off work, the harder it is to actually get back to work, to try to exercise some of those muscles, etc., that you may have used in a pre-work environment or a pre-injury environment. So it's really important, and actually it's part of the WSIB mandate, is to have the worker return to work as soon as is safely possible, and to help manage that return to work process in a way that supports the employee's recovery. So wage replacement is if you actually do miss time at work, WSAB will pay a portion of your wages so that you still receive your regular income while you have missed that time as a result of an injury. They will also provide coverage for healthcare and treatment. So if you have things like physiotherapy that you need to attend to or any other type of therapy to help with your recovery, then WSIB will pay for that. Ultimately, with the goal of supporting your return to work. And it is your choice of the healthcare provider that you go to. They will support your choice when it comes to physiotherapy and things like that. They don't dictate who you need to attend. That said, if there is a disagreement around the injury, the nature of the injury, or how it may have happened, there may be additional independent medical that might be required for you to attend. And usually the WSIB will determine who you will need to go to for that. But that's a very rare circumstance and doesn't happen on a typical WSIB case. So the other important part of the interaction with WSIB is really stay engaged with regards to your claim. So you want to keep your contact information up to date if you moved or if your mailing address has changed. It's really important to make sure that you make them aware of that. You want to make sure you respond to their requests. I have seen it in the past where if people did not respond, the claim gets closed and the worker has to appeal in order to get access to the benefits that they may have needed during that time. And make sure you keep copies of everything that they send to you to make sure that you can have a record of the engagement so far, and then you have your own notes as well. So the next important part, as I mentioned, safe and return to work is the best possible circumstance after a workplace injury. And as I mentioned, the goal is to help the individual get back to their pre-injury state without risking recovery. So returning can be gradual. Sometimes, depending on the nature of the injury, it could be that you return to work right the following day after seeking medical treatment, and that is the end of it. At other times, there might be a gradual return to work because of an additional injury, or there could be modified duties. So let's say that your typical job required you to be standing all day, but you ended up having an ankle injury that does not allow you to stand all day. There might be modifications made to the workstation so that you can stand and sit alternatively, or reduced hours in your shift, or a temporary other assignment to a different location in order for you to be able to be at the workplace and slowly and gradually return to your pre-injury work. Cooperation definitely goes both ways. Your role is to participate in the safe and return to work, and your responsibility is to stay in communication with your employer, share information about what you can or can't do, and participate in planning your return. So really overall be cooperative in the process. Engage with the employer in trying to figure out what would be the best possible modifications for you to be able to do your job safely and to the best of your ability. You do have a right not to be pushed or pressured back to work before it is safe to do so. That said, having good conversations with your medical practitioner will help you with determining what kind of work you can do. Like I said, the goal is really to return people to work as soon as possible after an injury in a way that is safe and respects their recovery. But that might mean it will be an alternate role so that while you're recovering, say, a leg or an arm injury, then perhaps there's other work that you can do that doesn't require you to use the part of your body that is potentially injured so that you can do other meaningful work and it keeps you in the workplace, which is very important for our not only our physical but also our mental health. So what is the balance? So health comes first, but really within a framework of cooperation. If you feel that the plan is not appropriate or you're not being treated unfairly, you can always raise that as a concern with WSIB. You will be assigned a caseworker as who is managing that claim that you have with them, and they can be an advocate for you with the employer if it is challenging. The next section is really about accommodation. So what does accommodation and accommodation in the context of any type of disability that you might experience that affects your ability to do your job. So this is not just about having been injured in the workplace. If you as an individual are requiring accommodation because of an injury outside of work or because of a circumstance or human right that is protected, it is very important that you raise that with the organization. There is another act called AODA, and it is and the AODA is about helping Ontarians in Ontario who have disabilities be accommodated and making workplace accessible to them so that they can perform the duties of their job. And so what that means is that under the Ontario Human Rights Code, you have the right to be accommodated for a disability. And like I said, other protected grounds like religion or family status. And this applies whether or not your situation is related or connected to a workplace injury. Like I said, this is something that is, it could require accommodation as a result of a workplace injury, but this accommodation process is standalone. It is something that you are entitled to as an individual who might be living with a disability. That said, accommodation is a conversation. It's not a demand. So accommodation is worked out together in collaboration with the employer. You explain what you need from your employer. You explain what it is that you need accommodated, and then the employer will work with you on a solution. Now, what do you share with the employer is what you share with the employer is protected by privacy, and you would not share any medical information or any medical diagnosis or details of your medical condition with your employer. That is not something they need to know any of the details about. What they do need to know, though, is how a medical condition, if it is an accommodation for a medical condition, how that medical condition affects your ability to do your job. So when you bring forward a request for accommodation from your employer, they will respond to you with, well, how does this need, how is your condition or what it is that you need accommodation for affect your ability to do the functional requirements of the job? They may give you a form that you need to take to your doctor or healthcare provider so that they can fill out and understand here's what the job entails, here's what the employee needs or can do or can't do as part of that job, and then they'll return it to the employer, which the employer will review, and then they'll work together with you to figure out an accommodation that works for both. Some examples of that, of course, are things like modified duties, might be schedule changes depending on what the requirements are. It could be some sort of assistive equipment that is needed for the location or for the job where you are doing most of your work. It might require some time off for treatment. or a quieter workspace or anything of that nature. So those are the types of accommodations you might experience in the workplace. And the accommodation is required up to undue hardship. And that's a little bit of a mouthful. And essentially, what that means is that you are required to be accommodated up until the point that it is too much of a hardship for the organization to be able to manage. Usually, in most circumstances, that tends to be a financial bar. If the cost of accommodation far exceeds the employer's ability to provide that accommodation, that would be typically undue hardship. That said, it's really important to know that because you have requested an accommodation, that does not mean you are going to get your preferred accommodation or your preferred solution. It is the responsibility of both parties to work together on something that's collaborative and that works for both parties. So just to keep that in mind when you are getting accommodation, it may not be what's desired, but it is still what's needed. And so that would meet what is required for accommodation in the workplace. So just I jumped ahead there. So where to get help? So there's a number of places where you can get help within the workplace. If you're struggling with health and safety, I would always recommend you speak to your workplace or your supervisor or your manager first if you have a health and safety concern. Internally, there's always other options that you can pursue. It might be your joint health and safety committee. Or your joint health and safety rep where you can raise a concern. And then if you're not getting any results from having raised it there, you can always go to the human resources department or somebody in a senior leadership capacity that could potentially help you. If you've exhausted those options, then there are other places outside of the workplace that you can go to. You can always go to the Ministry of Labor and make a report, or you have a health and safety concern that's not being addressed. With regards to WSIB, you can always reach out to the individual who is helping manage your claim. There is the Office of the Worker Advisor where you can get free confidential help for non-unionized workers. If your organization is a union or has a union, you could always speak to your union rep, or you can go to your union to help guide you and advocate for you in a circumstance. I already mentioned WSIB and Ministry of Labor. And then, of course, there are settlement agencies and community legal clinics, and of course, organizations like RRAI that can provide you with some information and point you in the right direction where you can get help with any issues that you might be experiencing in the workplace. So just again, those three things to remember. You have rights within the workplace, and they are there to protect you from the moment you start working at your job. You do have a voice. Ask questions, ask for training, raise concerns, request accommodation, and a reminder, none of that is a favor. It is a requirement of the workplace. And again, they are not permitted to act against you for raising a health and safety concern in the workplace. That would be considered reprisal, and that is against the law. And three, you're not alone. There are lots of resources out there to help you, and many of them can provide support in your language of choice. So I hope this has been a helpful presentation for you today. If you do have any questions after this presentation, you can feel free to reach out to me at that email, samanthacarter@tracksoftware.ca. And again, Heatham, thank you so much for having me speak as part of your platform. And it's always